Hello friends, welcome to Prashant IAS. So friends, in the last class we have discussed till Article 15 Clause 2, and in this class we will continue our discussion with Article 15 Clause 3. So friends, let's begin. Now friends, Article 15 Clause 3 is an exception of Article 15 Clause 1. Okay, so it is an exception of Article 15 Clause 1. So now what is Article 15 Clause 3? So Article 15 Clause 3 says that the state is not prevented from making any special provision for women and children. Now what does it mean? It means that the government or the state is not restricted, is not prohibited from making any special law, any special policy for the welfare of women and welfare of children. Okay, it means that government can make special provisions, special laws, special policies for the welfare of women and for the welfare of children. Okay, now why this provision is included in the fundamental rights? So friends, we all know that children and women are prone to atrocities from very ancient time. Okay, so women are weak as well as children are weak, and our society is a male dominating society. So women and children are prone to atrocities from the ancient time. So this article empowers the government to make special laws, to make special provisions for the protection, for the welfare of women and for the welfare of children. Now friends, let's move further. So friends, then comes Article 15 Clause 4. Now what is Article 15 Clause 4? So first of all, it was introduced by First Amendment Act 1951. So friends, it was not in the original constitution. So it was not the part of original copy of the constitution. So when Parliament amended the constitution for first time, then Parliament included this article in the fundamental rights. Okay, so this article was introduced by First Amendment Act 1951. Now friends, what Article 15 Clause 4 says? So Article 15 Clause 4 says that nothing in this article or in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially or educationally backward classes of citizens, or for the scheduled castes and scheduled tribes. Okay, so what does it say? It says that nothing in this article means in Article 15 or in Clause 2 of Article 29. So what is Clause 2 of Article 29? So it is related to admission in educational institutions. So when we will study about Article 29, we will discuss about it in detail. Okay, so nothing in this article and in Clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially or educationally backward classes of citizens or for scheduled castes and scheduled tribes. Now what does it mean? So it means that, for example, if any particular class of citizen is educationally backward as well as socially backward. So socially backward means the social status of that caste is very bad. Okay, so it is a very socially backward class, as well as the educational background of almost all the people of that caste is very very bad. Means this caste is socially backward as well as educationally backward. So friends, according to Article 15 Clause 4, if any particular class of citizen, for example any caste, any community, okay, so if any particular class of citizen is socially backward and educationally backward, okay, then state means government can make provisions for the welfare and advancement of this class of citizen. Okay, For example, state can make special provisions for the welfare of scheduled castes. State can make special provisions, laws, policies for the welfare of scheduled tribes. Okay, so Article 15 Clause 4 says that if any particular class of citizens is educationally backward as well as socially backward. For example, scheduled castes and scheduled tribes. So if any particular caste class of citizens is socially backward and educationally backward, then the government has the power to make special laws, special policies, special provisions for the welfare, for the advancement of this class. Okay, so this is the meaning of Article 15 Clause 4. So under Article 15 Clause 4, even reservation policy is valid. Why? Because what is reservation policy? Actually, reservation is a special provision for the protection of scheduled castes, scheduled tribes, or the classes which are educationally and socially backward. Okay. So now let's move further. So friends, then comes Article 15 Clause 5. Now what is Article 15 Clause 5? So first of all, Article 15 Clause 5 was introduced by 93rd Constitutional Amendment Act 2005. Okay, what does it mean? It means that it was originally not the part of Constitution. So it was not the part of original copy of the Constitution. When Constitution was made, it was not included in the Constitution. So when Parliament amended the Constitution for 93rd time, okay, so by 93rd Constitutional Amendment Act 2005, it was included in the Constitution. So it was introduced by 93rd Constitutional Amendment Act 2005. Now friends, what this article says, what is the language of this article? So it empowers the state to make special provisions for the admission of backward classes of citizens in educational institution, including private institution, whether aided or unaided, except in minority educational institution. So what does it say? So it says that it empowers the state to make special provisions for admission of backward classes of citizens in educational institution, including private institution, whether aided or unaided, except in minority educational institutions. Now what does it mean? So it means that government has the power to make law. Okay, government has the power to make law, and by law government can reserve certain seats in all the educational institutions for the members of backward class. Okay, now what does it mean? So friends, now suppose there is a backward class of citizens. Okay, so if there is a backward class of citizens, for example SC is a backward class, definitely the communities which are in ST, they are also backward class. Okay, so suppose let's take the example of SCs. Okay, so now government has the power to reserve some seats in all the educational institution for the members of SC community. Okay, so the people who belong to SC community, government will reserve certain seats in all the educational institutions, means schools and colleges, for the members of SC community. Okay, so what does it mean? It means that government, by making a law, can reserve certain number of seats in all the schools and colleges for the members of backward classes. Backward classes, for example, SCs and STs. Okay, now friends, government can reserve seat in any educational institution. For example, government can reserve seat in government owned educational institution. Government owned educational institution means the institutions means the colleges and schools which are owned by the government. Okay, now government can also reserve the seat in privately owned institutions. Okay, now government can reserve the seat in private educational institutions which are aided by the government. Aided by the government means which are funded by the government. Government gives them financial help. Okay, now friends, government can also reserve the seat for the member of backward classes in the private educational institutions which are unaided by the government. Means government does not give financial help to such educational institutions. Okay, so government can reserve the seat in any educational institute, means in any school or any college, for the members of backward class, for example for the members of ST and for the member of SCs. But friends, there is one exception. The exception is minority educational institutions. So government do not have the power to reserve any seat of minority educational institution. Okay, government do not have the power to reserve any seat of minority educational institution for the members of backward class. Okay, now what is a minority educational institution? So I will teach you about this when we will study about rights related to culture and education. Okay. Now let's move further. So friends, then comes Article 16. Okay, so what is Article 16? So what is Article 16? So friends, Article 16 is equality of opportunity in the matters of public employment. Okay, so what is Article 16? Article 16 is equality of opportunity in the matter of public employment. Now let's read all the clauses of Article 16, then you will get clear about what is the meaning of Article 16. So first of all, let's study Article 16 Clause 1. So friends, what Article 16 Clause 1 says? So Article 16 Clause 1 says that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any officer under the state. So what Article 16 Clause 1 is saying? So Article 16 Clause 1 is saying that there shall be equality of opportunity for all the citizens in matter relating to employment or appointment to any officer under the state. Now what does it mean? What is the meaning of this article? So it means that it is the duty of the state, it is the duty of the government to provide equality of opportunity, means to provide equal opportunity to all the citizens of India in the matters of public employment. Okay, so it is the duty of the government to provide equal opportunity to all the citizens of India in public employment. Now I will give you one example to explain this concept to you more clearly. Suppose friends, if there is a vacancy for any government job, suppose there is a vacancy for IAS, okay, then according to Article 16 Clause 1, it is the duty of the state, means it is the duty of the government to provide equal opportunity to all the citizens of India to become IAS. Now what does it mean? So it means that if there is any vacancy for IAS, then all the citizens of India who have certain minimum educational qualification and a age of 21 years of age, these all citizens can apply for IAS exam. Okay, so Article 16 Clause 1 says that if there is any vacancy for any government job, if there is any vacancy for any government job, then all the citizens of India who are having a minimum educational qualification and a certain age, okay, for example the age of 21, okay, so, and a certain age, they all can apply for that government job, and state will not discriminate between them. Okay, the exam should be fair and free. Okay, so equal opportunity should be provided to all the citizens for any government job, for any public employment. So this was Article 16 Clause 1. Now what is Article 16 Clause 2? So Article 16 Clause 2 is a more specific version of Article 16 Clause 1. Okay, it defines it more specifically. So what Article 16 Clause 2 says, that no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, residence, or any of them, be ineligible for, discriminated against in respect of any employment or office under the state. Okay, now what does it mean? So it means that state shall not discriminate between citizens. Okay, state shall not discriminate among citizens only on the grounds of religion. Okay, only on the ground of race, only on the ground of caste, sex, descent, place of birth, residence, or any of them. Okay, now what does it mean? It means that state is not allowed, means government is not allowed to discriminate between the citizens only on the ground of religion. For example, state cannot say that this particular religion, means the people belonging to this particular religion cannot apply for this government job. Okay, state cannot say that the people of this particular religion cannot become IAS officers. So what does it mean? It means that state shall not discriminate against citizens in the matter of public employment only on the ground of religion. Similarly, state cannot discriminate among citizens in the matter of public employment, means for government jobs, only on the ground of race. Means suppose if there is a person who is of Negro race and there is a person who is of Aryan race, then government cannot say that this particular job can be attained only by the person of Aryan race, or the person of Negro race is ineligible for this particular job. So state cannot say this. Why? Because race cannot be a ground of discrimination for any government job. Similarly, caste cannot be a ground of discrimination for any government job. For example, government cannot say that the people of lower caste, this particular job is only allowed to the people of lower caste. Upper caste people cannot enter into this job. Okay, for example, if there is a job of patwari, then state cannot say that only the people of upper caste are allowed to become patwari. No person from lower caste is allowed to become patwari. Similarly, this statement is also same for sex, descent, place of birth and residence. Okay, means for example, state cannot say this particular job is reserved for man or this particular job is reserved for women. Okay, so if we have to summarize Article 16 Clause 2, then we can say that according to Article 16 Clause 2, state shall not discriminate among citizens only on the ground of religion, race, caste, sex, descent, place of birth, residence, or any of them in the matter of public employment, means for any government job. Now friends, there are many exceptions of these two clauses of Article 16. Okay, so now let's go further. So friends, now what Article 16 Clause 3 says. So according to Article 16 Clause 3, under Article 16 Clause 3, Parliament is empowered to provide by law residence as a ground or qualification in getting certain categories of employment under the state. Okay, so in Article 16 Clause 2, what it was saying? It was saying that residence cannot be a ground of qualification, residence cannot be a ground to discriminate in the matter of public employment. But Article 16 Clause 3 is saying that Parliament has the power. Parliament has the power. By making a law, Parliament can provide residence as a qualification or as a ground in getting certain jobs, okay, of the nature of public employment under the state. Now what does it mean? So we know that there are certain jobs which are central government job and there are certain jobs which are state government job. Now Parliament has the power to make a law and say that this specific category of job can only be done by the people who are the residents of this particular place. Okay, so what Parliament can do? So Parliament has the power to make a law and say that this particular category of job, this particular class of job can now only be done by the domiciles of that state. Okay, so I know this is a little bit technical, so I will give you one example so that you can understand this more clearly. So friends, for example, what happens in Andhra Pradesh and Telangana, that group C and D jobs are only available to their domiciles. Now what are group C jobs? So group C jobs, for example, constable is a group C job. ASI, assistant sub inspector, it is a group C job. Similarly, what are group D job? Group D jobs means the lowest level of jobs. For example, peon is a group D job. Watchman is a group D job. So what happens in Andhra Pradesh and Telangana, that all the jobs of group C and all the jobs of group D are only available to the domiciles of Andhra and Telangana, means for their domiciles. So what Article 16 Clause 3 says, that Parliament has the power to make a law and to declare that this particular category of job can only be done by the domiciles of that state. Okay, so this is Article 16 Clause 3. Now friends, what is Article 16 Clause 4? So Article 16 Clause 4 empowers the state to make special provisions in the favor of backward classes of citizens in reserving the posts which are of the nature of public employment, provided that the said class is socially and educationally backward, and second, it is not adequately represented in the services under the state. Now what does it mean? So friends, again I will give you one example so that you can understand it very clearly. So friends, suppose there is one country. Okay, there is one country. Okay, and there are only 200 people living in that country. Okay, so there are only 200 people who are living in that country, and there are only 100 government jobs in that country. Okay, so there are 200 citizens of that country, and there are only 100 government jobs in that country. Now friends, if you will calculate the ratio, then you will say that sir, there are only 50% government jobs. Means 50% people of that country will get the government job. Okay. Now friends, suppose there are many communities in that country. Okay, there are many communities. For example, there are many communities in India also. So now I will not take the name of any community. Let's suppose some hypothetical communities. For example, there are many communities, community A, community B, C, D, E, F. Okay. So now let's suppose that there is a community A and there are total 20 people in that community. Okay. So there is a community named as community A and there are only 20 people of that community. Now, if you will go by ratio, then you can say that sir, at least 10 people of that community should be in the government job. Why? Because 50% of the citizens has to be in the government job. So similarly, the at least 10 persons from the community A should be the part of public employment, should be the part of government job. Okay. Now friends, according to Article 16 Clause 4, if community A is socially backward as well as educationally backward, means the social status of community A is very bad. It is considered a socially lower class. Okay, so it is a socially backward class. Similarly, the educational background of all the persons of most of the persons of community A is very bad. Means this community A is socially backward as well as it is educationally backward. So now first condition is satisfied. Now suppose I have told you that there are 20 people of that community. Now suppose only one person of that community is the part of government job. Means 19 people are doing something else and only one person is doing government job. So see the level of difference. Means at least 10% should be the part of government job, but only one person is the part of government job. So this means that the community is not adequately represented in the public service. Okay, so it means that community A is not adequately represented in the public service. So now both the conditions are met. So if both the conditions are satisfied, then the government can make special laws, government can make special provisions, and government can reserve certain post for the people of community A. Okay, so now government has the power to make law and reserve certain government seats, reserve certain government job, reserve certain seats in government job for community A. So this is what Article 16 Clause 4 tries to say, that it empowers the state to make special provisions in the favor of backward classes of citizens in reserving the posts which are of the nature of public employment, provided that the said class is socially and educationally backward, and second, it is not adequately represented in the services under the state. Now friends, Morarji Desai formed Mandal Commission in the chairmanship of BP Mandal in 1979. So what happened then? That Morarji Desai did, he formed Mandal Commission. Okay, and who was the chairman of Mandal Commission? The chairman of Mandal Commission was BP Mandal. Okay. Now friends, why this committee was formed means why Mandal Commission was formed. So Mandal Commission was formed to identify the classes which are socially and educationally backward and to find out how much they are represented in public service. So what happened in 1980? Mandal Commission gave its report and Mandal Commission identified 3,750 castes as educationally and socially backward. Okay, so Mandal Commission gave its report in 1980 and what Mandal Commission said that sir, 3,750 castes in India are socially backward as well as educationally backward. Now what was the second provision of report? Further, Mandal Commission reported that they were more than 50% of the population. Okay, now what according to Mandal Commission, these socially and educationally backward castes were more than 50% of the population of India. Okay, so Mandal Commission recommended at least 20% reservation to them in public employment. Okay, so what Mandal Commission said that sir, their population is more than 50% of the total population of India. So at least 20%, 27% reservation should be provided to them in the public employment. Now friends, what happened in 1991 that the recommendation of Mandal Commission was enforced by BP Singh. Okay, so in 1991 BP Singh enforced the recommendations of Mandal Commission and BP Singh gave 20% reservation to these backward classes, to these backward castes. Okay, and who was BP Singh? BP Singh was the then Prime Minister. So friends, then came Indra Sawhney versus Union of India case 1992. Okay, so which case came? India Sawhney versus Union of India case 1992. And this case clarified the position on reservation. Okay, so in this case, Supreme Court clarified the constitutional position or its own position on reservation. Now what court said? So court held that reservations in the favor of OBCs in public employment up to 27% is constitutionally valid. Okay, so what court said? Court said that as their population is more than 50% of the population of India, okay, and they are not adequately represented in the public employment, and they are socially backward as well as educationally backward. So 20% reservation in public employment in the favor of OBCs is constitutionally valid. So no problem in the first provision. So what court said that 20%, 27% reservation in the favor of other backward castes in public employment is okay. It is constitutionally valid. But court directed that state must identify the OBCs falling in creamy layer category and remove them from the benefit of reservation. What court said that it is the duty of the government, it is the duty of the state to identify that who are falling in creamy layer. Okay, so it was the duty of the government. So court said that it is the duty of the government to identify that the OBCs falling in the creamy layer category, okay, and remove them from the benefits of reservation. Now what is creamy layer? So suppose if you belong to OBC category and when you will become IAS, then you are not supposed to get the benefits of reservation. Why? Then because then you will become the part of creamy layer. Okay, so suppose you are a OBC and when you will become an IAS officer. Okay, so when you will become an IAS officer, then definitely you will not be educationally backward, you will not be socially backward, and you will also be empowered economically, you will also be empowered administratively. Okay, so then you will not remain backward and you will come into creamy layer. Okay, so when you will come into creamy layer, then your children will not get the benefit of reservation. So this is creamy layer concept. So Supreme Court said that it is the duty of the government to identify that who are falling in creamy layer category, to identify the OBCs who are falling in creamy layer category and remove them from the benefits of reservation because they do not read reservation. So when you will become IAS officer, then your children will not need the reservation. Okay. Then what was the second thing? So court held that ordinarily the reservation in the favor of backward classes shall not exceed 50% of the total seats. Now what does it mean? So suppose there is a vacancy for any public job. For example, there is a vacancy for sub-inspector. Okay, or for example, there is a vacancy for DSP, Deputy Superintendent of Police. Okay, now DSP is a government job. Suppose there are 100 vacancies. So court was saying that if there are 100 vacancies, then number of reserved seats must be less than or equal to 50. Okay, so suppose if there are 100 vacancies, so the number of reserved seats in the favor of backward classes, it should be less than or equal to 50. Okay, so what code was saying? So code was saying that ordinarily means generally the reservation in the favor of backward classes shall not exceed 50% of the total seats. So if there are 100 seats, then 51 seats cannot be reserved. Only maximum 50 seats can be reserved. Now what was the third thing which court said? So court said that reservation allows the benefit to backward classes only at entry state, and that is at the time of recruitment. Okay, therefore reservation for SCs and STs in promotion was declared unconstitutional. Now what does it mean? So it means that, for example, when you are recruited for any government job, so court was saying that when any person is being recruited for any government job, at that point of time you can give reservation to him. But when he is a part of service, when he is already a part of service, then you cannot give reservation in promotion. Now what is promotion? So suppose if you are recruited in police department as sub-inspector, so then you will be promoted to TI, means town inspector. Okay, then you will be promoted to DSP, means Deputy Superintendent of Police. Okay, now the name of post is different in different states. Okay, because policing is a subject of state list. Now friends, so what code was saying? That reservation should not be provided in promotion. Reservation should only be provided in the entry, in the recruitment. Now why reservation in promotion is not good? Okay, so question arises that why code was saying that reservation should not be provided in promotion. So now let's suppose one condition. Suppose you are recruited in police department as SI, sub-inspector. Okay, and there is a person who is your junior. Suppose he is ASI, assistant sub-inspector. Okay, now you belong to general category, and the ASI working under you belongs to SC or ST or any backward class. Okay, now there is promotion for there is reservation in promotion for SCs and STs. So you will remain SI, the person will get promoted and he will become SI. Okay, no problem, you are SI, he is SI. After that you will remain SI, but he will get promotion again and he will become TI. Okay, then you will remain SI only and he will get promotion and he will become DSP, Deputy Superintendent of Police. So due to reservation policy, the promotion is very fast for the people of SC and ST. Okay, so friends, this is just an educational content, so please don't take it otherwise. Okay, so this is a disclaimer that don't take it otherwise. This is just an educational content to explain you what court was trying to say. Okay, now friends, suppose if there was a person, okay, who was ASI, you were SI. Okay, he was under you and you were his boss. Now after 4-5 years you are SI but he is DSP, means now he is your boss. Earlier what was happening, that you were giving him orders and he was receiving orders from you. But now what is happening, that he is giving you order and you are receiving orders from him. So what happens, that this demotivates the people from general category. Okay, so this demotivates him and now they don't want to work. So due to this condition, Supreme Court ordered that no reservation will be provided in promotion to the members of SC and ST community. But friends, what Parliament did? Parliament responded by introducing Article 16, Clause 4, capital A. Okay, so now Parliament again amended the Constitution and Parliament introduced Article 16, Clause 4, capital A through 77th Amendment Act 1995, which provided for reservation in promotion for SC and ST. So Supreme Court ordered that the promotion for SC and ST the reservation for SC and ST in promotion is unconstitutional. So what Parliament did? Parliament amended the Constitution, and Parliament wrote it in Constitution that now government has the power to provide promotion to provide reservation to SC and ST in the promotion. Okay, then friends, what happened later on? So government started giving reservation to the members of SC/ST community in promotion also. But what happened that later on many state high courts put a ban on this many state high courts, including the High Court of Delhi and Punjab High Court, what they did, they put a ban on Article 16 Clause 4 capital A. Okay. Then friends, then came Nagraj versus Union of India case 2006. Now friends, Supreme Court in this case clarified that reservation policy is valid only when it satisfies 5 requirements. Okay, so Supreme Court said that reservation policy is okay, no problem in reservation policy, but it should follow these 5 conditions. So what are these 5 requirements or 5 conditions? So let's study them one by one. So the first condition was the said class should be socially and educationally backward. Means Supreme Court was saying that state should not give reservation to anyone. Okay, at least the class to which state is giving reservation, that class should be socially and educationally backward. Okay, so the first thing Supreme Court said that this class to which state is giving reservation should be socially backward as well as educationally backward. Okay, now what was the second thing? The said class must not be adequately represented in the public service. Okay, means for example, I have given you an example of a country. Okay, that there were 200 persons in a country, and there was a community A, and community A had 20 persons, and only one person was in the public service. Okay, and according to the ratio, 10% should be the part of public employment, but only 1% was the public employment. So we can say that the community A was not adequately represented in the public service. So Supreme Court said that the said class, means the class to which state is giving reservation, that class must not be adequately represented in public service. And if that class is represented in the public service adequately, then government has no power to give him reservation. Now what was the third point? So third point is concept of creamy layer must be applied in the case of OBCs. Okay, so I have to just explain you what is creamy layer. So the concept of creamy layer must be applied in the case of OBCs, and reservation must not be provided to the members of OBC who are falling in creamy layer category. Now what was the fourth point? So the fourth point was that total reservation in the favor of backward classes ordinarily shall not exceed 50% of total seats. So what Supreme Court said, that the total reservation in the favor of all the backward classes shall not exceed 50% of the total seats. For example, if there are 100 seats, 100 vacancies for any government job, then government can provide at max reservation for 50 seats, or less than that. Government cannot provide reservation for 51 seats. Now friends, what was fifth provision? So fifth provision was journal efficiency of the administration must be maintained. Now what is this? This is something new. So what is this? What is the journal efficiency of the administration? So I will give you one example to explain this concept to you. Okay, so suppose friends, there are vacancies for the post of government doctor. Okay, for the post of doctor. Now friends, there is a person who belongs to general category. Now suppose the maximum marks of paper is 500. Okay, now suppose there are 100 vacancies and 10 seats are reserved for a specific community. Okay, 10 seats are reserved for a community which is educationally and socially backward and which is not adequately represented in public service. So for a particular community, 10 seats are reserved. So how many vacancies? 100 vacancies. How many seats are reserved for one specific community? 10 seats. And what is the maximum marks of paper? 500 marks. Now suppose the topper from that community, means I am talking about the people belonging to that community. Suppose community A. So suppose the topper from that community scored only 30 marks. Okay. Now suppose friends, a person who is getting only 30 marks out of 500 marks, if you will make him doctor, what he will do with his patients? He will definitely kill his patients. Why? Because he don't know anything about MBBS and anything else. He don't know anything about medical science. Okay, so if you will make doctor to a person who is just scoring 30 marks out of 500 marks, then how he will be able to cure his patients correctly? So it means that the journal efficiency of the administration will be disturbed. So now what Supreme Court said, that journal efficiency should not be disturbed. So what government did? Government brought the concept of cutoff. Means for example, if the paper is containing 500 marks, okay, and the person belonging to general category need 400 marks to clear the paper, then the person belonging to ST, SC or any backward class needs suppose 350 marks to qualify the paper. Okay, so if a person from a general category needs 400 marks to clear the exam to become a doctor, so now a person from backward class, means person from SC, ST or any other backward class, he needs at least 350 marks to clear the paper. Now you will ask that, sir, what will happen if no person is able to score 350 marks? Then the seats which are reserved for the said community will be remain vacated. Okay, they will remain vacant. Okay, and no person from any other community will be recruited on these seats. So they will remain vacant. And when the exam will be conducted next time, then these seats will be included again. Okay, so cutoff concept was introduced to maintain the general efficiency of the administration. So this was the fifth point which Supreme Court said. So friends, now let's move further. So then comes Article 16 Clause 5. So what Article 16 Clause 5 says? So friends, Article 16 Clause 5 empowers the state to prescribe religion as a ground or qualification for recruitment in certain categories of public employment. So what Article 16 Clause 5 is saying? Article 16 Clause 5 is saying that state is empowered. It empowers the state to prescribe religion as a ground or qualification for recruitment in certain categories of public employment. Now what does it mean? So it means that state or the government has the power to reserve certain category of government jobs. Okay, to reserve certain category of government jobs to the persons of any specific religion. Okay, for example, government can reserve certain jobs for the people belonging to Hindu religion. Government can reserve certain jobs for the people relating to Muslim religion, Islam religion. Okay, so Article 16 Clause 5 says that government has the power to reserve certain government jobs, to reserve certain public employments for the people of one specific religion. Now you will say that, sir, it is an exception of Article 16 Clause 2. Yes, definitely it is an exception of Article 16 Clause 2, but it is also very important. So I will give you one example so that you will understand that why it is important. So friends, for example, only a Hindu can be a priest in Jagannath temple. Now you know that Jagannath temple is a holy temple of Hindus. Okay, so how Hindu people will tolerate that any Muslim, Christian, Parsi or a person from any other religion become the head priest? So it is not tolerable by the people of Hinduism. Okay, so it is a must that the priest of a mandir, priest of a temple should be a person who belongs to that religion only. So it is a must that only a Hindu person can become a priest in Jagannath temple. Okay, so it means that state has the power to prescribe religion. Okay, to prescribe religion as a ground or qualification for recruitment in certain categories of public employment. Means government has the power to reserve some government jobs for the people belonging to one specific religion. For example, the priest of Jagannath temple who can become the priest of Jagannath temple? Only a person who belongs to Hindu community, Hindu religion. Means only a Hindu can become a priest in Jagannath temple. Okay, and it is also very important for maintaining peace in the society. Otherwise, people will not tolerate this. Okay. So friends, that's all for today. In the next class, we will start our discussion with Article 17, Abolition of Untouchability. So friends, I have uploaded the link of notes in the description of video, and you can also download the notes from my blog. You can also follow me on Instagram. My user ID is Prashant IAS7. And friends, I hope that you all must have enjoyed the lecture, and if you have enjoyed the lecture, so please like the video, use the comment section, subscribe to my channel, press the bell icon so that you can get notified whenever I upload video. Okay? And definitely I will upload video daily so that your syllabus is completed on time. So friends, till then, take care of yourself. Thank you.